All rise. 53rd Circuit Court is now in session. The Honorable Roy J. Meek presiding.
You may be seated. Calling the cases of People versus Robert Anthony McCauley. Counsel, identify for the record, please.
Good morning, Your Honor. Mark Webb on behalf of the people.
Please, the court, Scott Moore for the defense.
And you are Robert Anthony McCauley?
Mr. McCauley, you need to unmute your microphone.
Can you hear us, Mr. McCauley?
Hear me?
Yes, now we can. All right. This was scheduled as a pretrial. A pretrial summary has been furnished to the court. Anything further, Mr. Moore?
No, Your Honor, except to say that as regards the jail prisoner possessing contraband case, we're very close to a resolution. We're going to ask the court to delay that to a status conference along with contraband case, which is 21-6566. We will be filing a motion within the 28 days as provided in the pretrial summary. But as I said, one case is very near conclusion, pending the resolution of the motion to be filed in that other case. Thank you.
All right. So do you want us to set a status conference 30 days out?
Status conference hearing date, yes, Your Honor. I would imagine the hearing wouldn't take more than an hour.
Simple.
Simple.
Probably only do the motion on one case over.
That's correct, Your Honor.
Anything further from anybody?
Just as a scheduling matter, Your Honor, and I don't have all the file numbers in front of me, but there are other cases that are pending, and to the extent possible, that's the clerk arranged to have everything heard at the next hearing date, including the sentence.
All right. So we'll set all cases for that next hearing date and allow for at least an hour, if not an hour and a half.
Yes, Your Honor. Thank you.
You're all set, Mr. McCauley.
All right, thank you.
We have Mr. Barnard.
We have Mr. LeBon and Mr. Ackerman.
Mr. Bonner will not be calling out.
Okay.
I don't know that we need to take care of that on record, but the writ was canceled. DOC advised me that he was on quarantine.
Okay.
I let the prosecutor know, so we were not expected to proceed.
All right, so those cases will be adjourned. So we have next, who we have? LeBeau.
I have Mr. LeBon.
All right. Well, the case of People versus Brandon Charles LeBon.
Morning, Your Honor. Mark Webb on behalf of the people.
And please, the court, Scott Moore for the defense.
And you are Brandon Charles LeBon?
We'll need to unmute. Thank you.
All right.
Hello?
This was, we heard you.
Okay, sorry.
And this is a status conference. Anything new developed in this case?
Well, positively, Your Honor, my client continues to be a resident of the Lions Den Rehab Center and is doing quite well, according to his counselors.
Okay.
I've been advised that he has matters pending in Crawford County scheduled for hearing in about a month. My impression is the results of that case are bearing on this one, so I would, under the circumstances, ask for an additional extension of at least a month. Mr. LeBon, you're scheduled for release in approximately 5 months, is that correct?
Yes.
What we'll do is we'll set this for another status conference on June 14th.
Thank you.
All right.
June 14th.
Thank you, Ms. LeBone.
Thank you. Have a good day. God bless.
All right.
All right. June 14th, Flag Day.
Yep. A flag tie.
I don't. There's a statute out there saying we're not supposed to do that to the flag, but who cares anymore, right?
So you get one of those mock ones that just have stars on it.
Yes.
Red, white, and blue.
I'll strive to endeavor, Your Honor. Thank you.
I don't have one anymore.
I don't know who this is, a big deal.
Monty.
Mr. Monty.
He's going to need to unmute as well. Mr. Monty, can you hear the court? I need you to step toward the camera. You need to unmute your microphone, please.
In the case of the people versus Frank Eric Monty.
Good morning, Your Honor. Mark Webb on behalf of the people.
And please, the court, Scott Moore for the defense.
You are Frank Eric Monty.
You have to unmute your microphone. You have to keep it unmute, Mr. Monty.
Oh.
There you go.
Yes, I'm Frank Eric Monty.
Okay, all right. Pretrial summary has been forwarded to the court. Anything further for today, Mr. Moore?
Yes, Your Honor, we'll be accepting the offer and proceeding on count one of the amended information that we just now received. We waive reading of the information and waive preliminary examination.
All right. Mr. Monty, how old are you?
32.
You raise your right hand and be sworn.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
I guess.
Well, you know, we can't take, I guess. It's either yes or no.
I said yes.
Okay. Oh, it sounded like I guess, but okay. Thank you. And the court has been handed an amended information, and you've gone over the charges, Mr. Moore, with Mr. Monty?
Yes, Your Honor.
And, Mr. Monty, you're being charged with count one, controlled substance, possession of methamphetamine. That's a felony. It carries a maximum penalty of 10 years in prison. The minimum is discretionary with the court. You understand the charge and the possible penalties?
Yes.
And this may or may not include license suspension. You understand that?
Yes.
All right. There's one of three possible pleas you may make to this charge. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stand mute, in which event the court will enter a plea of not guilty. You understand the one of three possible pleas you may make.
Yes.
Answering to count one, controlled substance, possession of methamphetamine, how do you plead?
Guilty.
You understand that no one may make any promises for this court as to what your sentence will be.
Yes.
Court further informs you that if your plea is accepted, you will not have a trial of any kind and therefore give up the following rights. The right to have a trial by jury, the right to have a trial in front of this court sitting without a jury, the right to be presumed innocent until proven guilty, the right to be proven guilty beyond a reasonable doubt, the right to question all witnesses against you, the right to have this court order witnesses on your behalf into court to testify at trial, the right to remain silent and not have that silence used against you during trial, and the right to testify at trial if you wish to do so and have your testimony considered in the same manner as any other person's testimony. Do you understand these rights?
Yes.
You understand by pleading guilty, you give up each and every one of those rights.
Yes.
Mr. Webb, what is the plea agreement?
Your Honor, in exchange for the defendant's plea of guilty to count one possession of methamphetamine, we've already filed an amended information that excludes the second or subsequent drug offender notice. And I will dismiss count two as well as that second or subsequent notice at sentencing, since it wasn't taken off. And we're recommending, or we're agreeing to a Briggs Killebrew cap of 12 months at the Clare County Jail.
Mr. Moore, is that your full and complete understanding of the plea agreement?
Yes, Your Honor.
Mr. Monty, did you hear it was put on the record as the plea agreement?
Yes.
Did you understand it?
Yes.
And are you in agreement with it?
Yes.
Has anyone promised you anything beyond what was stated in the plea agreement to induce you to plead guilty?
No.
Has anybody threatened you or your family in order to induce you to plead guilty?
No.
Has anybody promised you that if you pled guilty, this court would be lenient upon you in any way?
No.
Is it your own personal choice to plead guilty?
Yeah.
And are you doing so freely and voluntarily?
Yeah.
Do you have any questions about what the court has told you?
I have one question.
Go ahead.
Would the court do an early release to a treatment facility, like as in Harbor Hall?
The court may. I'm not promising that we will, but I want to see a pre-sentence report first.
Yes, sir.
All right. Any other questions?
No, Your Honor.
Have you understood everything that the court has told you?
Yes.
In light of everything that the court has told you, do you still wish to plead guilty?
Yes.
Drawing your attention to on or about May 30th of 2020, were you in Grant Township, Clare County, Michigan at that date?
Yes.
And at that time, did you have in your possession some methamphetamine?
And there was that in the car, yes.
All right. And did you know it was methamphetamine?
No.
And did you have any license or prescription to have it in your possession or in the car?
No.
And did anybody else in the car have a license or prescription for it?
I don't know, no.
Satisfied with the factual basis, Mr. Webb?
Yes, Your Honor.
Satisfied with the factual basis, Mr. Moore?
I don't want to gild the lily, Your Honor, but based on the statement, I would ask the court to take judicial notice of the Michigan State Police Forensic Science Division Laboratory report dated June 26, 2020, record number 1, indicating that item 1 of the evidence gathered in this case indicated the presence of methamphetamine in a sample that weighed 0.158 grams. Thank you. With that, yes, we're satisfied.
Yeah, for the record, I have no knowledge of anybody ever being given a prescription or being given a license to have possession of methamphetamine.
Perhaps I misheard my client, Your Honor, but I thought he said he did not know that it was methamphetamine. So I'm asking the court to take notice of
Okay.
the lab result.
Yeah, I think he stumbled there.
Very good, Your Honor. In any event, that's all I was trying to do. And I agree.
All right.
I don't think you can prescribe methamphetamine, to be honest.
So we. All right. Does court comply with the court rules, Mr. Webb?
You have, Your Honor.
Court comply with the court rules, Mr. Moore?
Yes, Your Honor.
Court finds a factual basis for the plea. Court is convinced that the plea is knowingly, voluntarily, understandably made. Plea is accepted in order to enter upon the records of this court. Sentencing will be set for June 14th. You want it set at 8:45 a.m. or you prefer 9 a.m. or?
Well,
8:45 still working?
it is, Your Honor. When we have people coming in, that was really the reason for that. But yes, 8:45.
All right. 8:45 a.m. Defendant is referred to the Department of Corrections for the preparation of a pre-sentence investigation report. Bond is canceled. Case is adjourned to the date time set for sentencing. You're all set, Mr. Monty.
Thank you.
Thank you, Mr. Monty. May I approach?
You may. I know your sheriff's usually still here before 9, so.
That's good. That's what you're ready for.
Okay.
Certainly not important.
Who we have next?
We have Mr. Mackey, but I think we're waiting on the jail to bring him over. Yeah, not there yet. And then we have Mr. Ackerman that I can bring into the courtroom right
All
now.
right, let's do that. Calling the case of the People versus Kyle Thomas Ackerman.
Good morning, Your Honor. Mark Webb on behalf of the people.
And please, the court, Scott Moore for the defense.
And you are Kyle Thomas Ackerman? Need to unmute.
Yes, Your Honor.
All right. And this was just set as a status conference. We still have a trial date set for June 24th. That's going to be canceled, adjourned, and a new date will be set. Because we're not ready for a jury trial yet. So, anything you wish to discuss today, Mr. Moore or Mr. Webb?
I have nothing, Your Honor. Thank you.
Your Honor, I think the thing that is hanging this case up would be my estimate of guidelines, which I do estimate it being 19 to 38 months. I think that if we were to set this for another status conference, especially in light of the adjourned jury trial date, I think that it could bear fruit, but I want counsel on the court to be aware that was my estimate of the sentencing guidelines, and that my client would probably plan for that if we can't get past that barrier. Thank you.
Okay. You want to have that as off the record and maybe talk with the probation department regarding the record?
Yes, Your Honor.
So that we can get maybe a closer estimate of what they are.
Very good, Your Honor. Thank you.
All right. We'll set this for a status conference on May 24th at 8:45 a.m. Unless you prefer like an off motion day for that.
I'm with you. Thank you for
All
asking.
right, so we'll set it for a non-motion day. So we'll take it off May 24th. All right, so we'll send out a notice of when that is.
Mr. Ackerman, pay attention to your mail and your texts so that we get the next date to you, okay?
All right, sounds good.
This is Mr. Mackey.
In the case of the People versus Jonathan William Mackey.
He's unmute his microphone as well. Sir, will you unmute your microphone?
Good morning, Your Honor. Mark Webb on behalf of the people.
Please, the court, Scott Moore for the defense.
You're Jonathan William Mackey.
Which is ironic because he'll be standing mute.
So this is an arraignment. All right.
It
There we
is.
go, he's unmuted.
Okay. And you are Jonathan William Mackey, is that correct?
Yes, sir.
All right. And, Mr. Moore, this is an arraignment, and you said your client will be standing mute?
That's correct. We've received the information, waived reading of the information, made preliminary examination. The record should reflect that my client is on parole, so this is dead time. I'm going to ask the court to schedule this pretrial conference on May 24th, if we can fit that in.
All right,
Unless we can get in earlier than that. But I
you
think
can
that-
probably get in earlier than that, but I think that might be scheduled. We'll try to schedule it earlier. Not guilty pleas will be entered on behalf of the defendant. We'll try to schedule this for May 10th at 8:45 a.m.
Much obliged, Jerry.
You're all set, Mr. Mackey.
I think all we have left is Gruba, who will have to be brought over, the jail. So that's all we're waiting for Mr. Moore and Manny with Karen Tomchek, correct?
He's not going to be here for that either.
No, but are you gonna address that with Ms. Tomchek
Yeah,
while you're
sure.
here, so we don't waste your time?
Hey, hey.
Mr. Gruba is demanded to be brought into the courtroom, or is he?
No.
He's just, okay, just we have to wait. for
Yeah, we
the
just
jail.
have to wait for the sheriff's.
And I think we're going to proceed with a plea.
Mr. Manny will not be here. Karen is still logged in. I don't know if she's.
And I just got an email this morning saying that whatever facility he's in, he won't be doing it because of COVID.
Correct, and I didn't know if there was something that they had regarding, because one is a PV and one is a
Okay.
status now, or a new case.
All right, so it may be changing attorneys,
Well,
or doesn't matter,
I think that's the question. He has two lawyers.
two cases.
One's a PV that's been amended to now include my newer felony. I know that Dr. Moore had, and I think Karen's listening to us, Dr. Moore had given us the option of consolidating or not, and I think just I let it drift.
Okay. Tomchek, are you present?
Yes, Your Honor.
All right, so I'll call the cases of the people versus Anthony James Manny. Counsel identified for the record.
Good morning, Your Honor. Mark Webb on behalf of the people.
Please support Scott Moore, file 21-6573-FC.
All right.
Morning, Your Honor. Karen Tomchek and file 19-6216 FH.
All right. Mr. Manny has two different cases. One's a probation violation, one's a new charge. Two different attorneys. And what's your pleasure?
Well, Your Honor, I would be asking for an adjournment because my understanding is that the underlying case has not been resolved, and the fact that the facility is now under quarantine and we don't have Mr. Manny here, I don't think there's much we could do anyways.
All right, so an adjournment, your case will be granted. Both of you want to continue with your own separate cases, or do you wish to consolidate and have both cases assigned to one attorney?
Well, Your Honor, seeing as we'd already addressed this with indigent defense, I have no problem continuing on separate cases. I also don't have any problem if the court wants to continually set the matter at Mr. Moore's time, just for ease of appearance.
Or in the alternative, we could set Mr. Manny at Ms. Tomchik's time, and I could stand around,
All right. Well,
which is fine.
So we'll run the two cases together, and we'll probably set it at your time, Mr. Moore.
Thank you.
All
And
right.
thank you, Ms. Tomchik.
And do you want this set in 2 weeks or 30 days?
I would say, let's say 30 days just to be safe with the quarantine's gonna be at least 2 weeks.
Yes, all right.
And I would make a record of this. I just happened to be in the Aranac County Circuit Court when Mr. Manny was sentenced to prison. So I was aware that he was riding out. I was not able to contact him before he left. I have not spoken with him since he's left the jail here. We did and continue to make efforts to coordinate a meeting through whatever prison he's in right now. I believe it's still in Eglin, in his quarantine.
That's
So
my understanding.
that facility, it's extremely difficult for attorney-client conferences to be scheduled. But we are endeavoring to do that.
So maybe we should set it out farther, 60 days.
I would propose this, Your Honor, if we can't schedule a meeting within like a week before, we'll ask for an adjournment. Okay, because I really do need to consult with him, and I think Ms. Tomczyk does as well, and we can probably coordinate our times.
All right, we'll set this right now for May 24th, but if you have problems, just contact the court and we'll adjourn it.
Yes, Your Honor.
All right.
Thank you, Your Honor.
In the case, People versus Randy Allen Grubau.
Please, the court, Scott Moore for the defendant probation.
Mr. Grubauer, can you please unmute your microphone?
Should be good.
All right, you are Randy Allen Grubau?
Yes, sir.
Mr. Webb, we still have you in prison?
Yes, Your Honor.
Oh, okay, but this is a probation hearing. All right.
Right. That's why I videoed off.
Okay, you're all set then. All right. Mr. Grubau, you're on probation for assault with intent to do great bodily harm less than murder. That is a felony, carries a maximum penalty of 10 years in prison. A 3-count violation has been filed against you. How do you wish to proceed today, Mr. Moore?
Your Honor, I've had discussions with Agent Ween, and we are in receipt of the current probation violation report that outlines the recommendation. We have not discussed the actual counts to be pleaded to. It's my understanding that count 1, where it's alleged that Mr. Grubauer committed retail fraud, that has not been adjudicated through Isabella County. However, I believe we can proceed with some safety on counts 2 and 3, and then we would ask the court to adopt the recommendation.
All right.
If the department has no objection to that, of course.
No objection, Your Honor.
Did you hear that, Mr. Grubauer?
Barely.
Basically, what your counsel is proposing that you plead to counts 2 and 3. Count 1 would be dismissed, and he's asking that the court follow the recommendation of the department regarding any sentencing. You understand that?
Yes, sir.
And you're in agreement with that?
Yes, sir.
All right. How old are you?
23.
You raise your right hand and be sworn.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Grubauer, count 2 is violation of Rule 3. Count 3 is violation of Rule 4. There's one of 3 possible pleas you may make to these charges. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stay on mute, in which event the court will enter a plea of not guilty for you. You understand the one of 3 possible pleas that you may make?
Yes, sir.
Answering to count 2, how do you plead?
Guilty.
Answering to count 3, how do you plead?
Guilty.
If your pleas are accepted, you will not have a hearing of any kind and therefore give up the following rights: the right to have a contested revocation hearing, the right to be represented by an attorney, the right to a court-appointed attorney if you're unable to afford one. Mr. Moore has been appointed to represent you in this matter. That the maximum possible sentence could be 10 years in prison. The minimum is discretionary with the court. that you give up the right to appear at a hearing, present evidence, and cross-examine witnesses. You give up the right to have the prosecution or probation office establish a violation by a preponderance of the evidence. You give up the right to remain silent and not have that silence used against you during the hearing. And you give up the right to testify at the hearing if you wish to do so, and have your testimony considered in the same manner as any other person's testimony. Do you understand these rights?
Yes, sir.
Do you understand by pleading guilty, you give up each and every one of those rights?
Yes, sir.
Has anyone promised you anything beyond what was stated in the plea agreement to induce you to plead guilty?
What was the plea agreement?
Can you hear Mr. Grubauer?
No, what was the plea agreement?
Yeah, that's what I'm asking. Can you hear me?
Yes.
All right. The recommendation is if you plead guilty, 12 months jail with credit for 192 days served and unsuccessful discharge from probation. That's what we discussed last night by Zoom. Do you remember?
Yes, sir.
Okay, and that's your understanding of the agreement. Is that right?
Yes, sir.
Okay, thank you.
You're welcome.
So again, has anyone promised you anything beyond what was stated in the plea agreement to induce you to plead guilty?
No, Your Honor.
Has anybody threatened you or your family in order to induce you to plead guilty?
No, sir.
Has anybody promised you that if you pled guilty, this court be lenient upon you in any way?
No, sir.
Is it your own personal choice to plead guilty?
Yes, sir.
Now you're doing so freely and voluntarily.
Yes, sir.
Do you have any questions about what the court has told you?
No, sir.
Have you understood everything that the court has told you?
Yes, sir.
In light of everything that the court has told you, do you still wish to plead guilty?
Yes, sir.
And part of your probation was to make a truthful report to the probation officer monthly or as often as the probation officer may require. Is that correct?
Yes, sir.
And is it true that on or about August 5th of 2020, you failed to meet with your agent?
That's correct.
All right. And part of your probation was to notify the agent immediately of a change of address or employment status. Is that correct?
Yes, Your Honor.
And is it true that on or about August 13th, you changed your residence without notifying your agent?
Yes, sir.
Court finds a factual basis for the plea. Has the court complied with the court rules?
Yes, Your Honor.
Where it is not agreed upon the possible plea or the possible sentence of either the prosecutor or probation officer or the defendant or anyone acting in the interest of either. Court is satisfied the plea is understandably, voluntarily, knowingly made. The plea is accepted in order to on the records of this court. Court is going to set this for sentencing on May 10th at 8:45 a.m. I haven't read the report, so
Very good.
I would like to read that report before I agree to sentencing in this matter.
Certainly, Your Honor. I would just ask the department, and I know they will anyway, but jail credit will have to be updated for the next year.
Yes.
All right. Bond is canceled, case is adjourned to the date, time set for sentencing.
Thank you.
That handles all your cases for this morning?
You know, for all the work I did yesterday, yeah, that's it. I spent a lot more time then than I did.
Preparation usually is more than.
Thank you.
You're all set, Mr. Grubauer.
All right, thank you.
We're off the record.
Circuit court's now in session, and Honorable Roy J. Meek presiding.
You may be seated. In the case of People versus Michael Todd Funnel, counsel identify for the record, please.
Good morning, Your Honor. Mark Webb on behalf of the people.
Morning, Your Honor. Todd Dietrich appearing on behalf of Mr. Funnel.
You are Michael Todd Funnel?
Yeah.
All right. This is a motion. You may proceed, Mr. Dietrich.
Thank you, Your Honor. Your Honor, I previously filed this motion. Essentially, at the preliminary examination stage, we were ready to go. Ms. Schwartz from prosecutor's office suggested that we waive up and try to negotiate the case in circuit court. We did waive up, did attempt to negotiate after some period of time. Mr. Funnell initially wanted to have his preliminary examination after the waiver, and the court had asked the question if we had basically substantive negotiations and trying to resolve the case. And at that time, we had not. And the court instructed us, the prosecutor and myself, to at least try to have some type of negotiation attempts. We've had numerous attempts to negotiate and settle this case. They have failed. And in the meantime, I've been contacted by the alleged victim, who's made recanting statements. I've been advised that she made these statements to the prosecutor's office to no avail in terms of resolving the case. So I was asked to, again, attempt to get a preliminary examination. I did note in the response to the motion that states that Duncan was overturned or overruled by People versus Glass. And all I really quoted was that the preliminary examination was a fundamental right in most criminal cases. And what Glass overruled really was that there was a right to preliminary examination for individuals who had been indicted, and that was on a grand jury case. It was a limited overturn. I don't think the prosecutor meant to say that a preliminary examination is not a fundamental right in most criminal cases, which is all I quoted from that case. I'm not sure why they denied that the preliminary examination was initially set on September 21st, 2020. I have the notice right in my hand. It was dated August 31st, 2020 from the 80th District Court. And essentially, due to the fact that we certainly have an alleged victim that has made it clear to me that she's recanting based on certain circumstances. And I believe a preliminary examination is extremely important in this case. And Mr. Funnell does as well. And he's desiring to have the case remanded to the 80th Court for a preliminary examination.
Response?
Your Honor, as Mrs. Ambrosiadis and Mrs. Schwartz have pointed out, People versus Glass is the controlling case, and there is no fundamental right to a preliminary examination. That's a creation of the legislature in our state. And additionally, MCR 6.008, which took effect on January 1st of 2018, eliminated any conditional waivers of preliminary examinations. First, I would argue there was no conditional offer or waiver in exchange for waiving exam. But if the court believes that there may have been, again, I would argue that it's not relevant and doesn't come under the three limited areas where you can remand for a prelim. Where there's a motion to quash and you find that there was insufficient evidence for a bindover, where the defendant waived the exam without counsel, or where the prosecutor added new charge or charges on which the defendant didn't have a prelim. So saying negotiations weren't fruitful or the victims recanted or whatever, those aren't relevant to this motion for you to take into account in deciding this motion. So based on that and our responses in our brief, I'd ask you to deny the motion to remand and keep this on the jury trial docket.
Stupid.
Rebuttal?
Well, Your Honor, I mean, essentially, there was certainly
Todd, you muted yourself.
muted yourself, so I can't hear what you're saying.
Can you hear me now?
Yes.
Okay.
That's Mr. Funnel.
Oh, I'm sorry. Sorry, he's talking to me.
So I'm sorry for the confusion, Your Honor. Essentially, it was basically there were statements made by the prosecutor's office that, when they say, hey, look, why don't you waive up the prelim and then we'll try to work it out in circuit court, somewhat implying that if we can't work it out, we can have a prelim. When we were discussing having a prelim, we were ready to have a prelim at that point in time. And then now they want to rely on these, no conditional waivers and so forth. I guess if that's the way the court wants to rule, then the court will rule that way. But the prosecutor should be aware that if that's the tone that's going to be had in the proceedings, and in the future that may not bode well for other cases. But essentially, Mr. Funnel has maintained his innocence, but thought that this matter could be resolved through further negotiations. And when we were here last on the prior motion, the court directed us to continue those negotiations, and we did, and it still has not been resolved. So Mr. Funnel had requested his right to have the preliminary examination.
Mr. Webb, I know you weren't involved in this case, but was there some kind of conversation? Why don't you waive and we'll discuss this in circuit court?
I have no idea about that, Your Honor. Only what I reviewed the transcript from the district court, and that's the only conversation I have any privy to.
All right, the court will take it under advisement and review it again and read the transcript. And, we'll go from there. I think we're set for status conference on June 28th. Court will probably set a status conference before that to rule on the motion. All right. Anything further from anybody?
No, thank you.
No, Your Honor.
All right. You're all set, Mr. Funnel.
All right, thank you.
Anybody else?
It does look like we have Robert Lucas. Todd, do you know of anybody named Mary that would be involved in your cases?
No, but I know sometimes people use other people's phones too, so I don't know. No.
If you don't mind, I'm gonna bring this person
Sure.
in just to make sure that I don't bypass him.
I'm sorry. Is anyone waiting for me or?
No, I'm waiting for the audio to connect to this individual to find out who it is and what they're here for. And it does look like we have Macosta on, so as soon as I find out who this person is, I'm going to bring in Macosta just so that they don't hang up. Good morning, ma'am. Can you unmute your microphone? Could you please identify yourself and state which case you're here for?
My name is Mary Hafer, Hafer, and I'm here for the John Federley hearing.
Ma'am, that A hearing will not be taking place today. The writ had to be canceled for that.
Okay. All right. Thank you very much.
You're very welcome.
We'll take a recess.
All right. The Honorable Roy J. Meek presiding.
You may be seated. Calling the case of People versus Robert Lee Lucas. Counsel identify for the record, please.
Good morning, Your Honor. Mark Webb on behalf of the people.
Morning, Your Honor. Todd Dietrich appearing on behalf of Mr. Lucas.
You are Robert Lee Lucas?
Yes, sir.
Previously, you appeared in court and pled to the charge of controlled substance possession of methamphetamine as a habitual criminal offender second. That makes that a felony with a maximum penalty of 15 years in prison. Minimum's discretionary with the court. The pre-sentence investigation report has been prepared. Sentencing guidelines have been determined to be 19 to 47 months. Mr. Dietrich, have you had an opportunity to review that pre-sentence investigation report with your client?
Yes, Your Honor.
Anything of a factual nature that you wish to add to explain or controvert in that report?
No, Your Honor.
Any objection to the scoring of the guidelines?
No, Your Honor.
Mr. Webb, on behalf of the people, anything regarding the report or the guidelines?
Your Honor, thank you. I've reviewed the report. I have no additions or corrections to make to it, and I would agree that the guidelines are correctly scored.
All right. Mr. Lucas, is there anything you wish to say to the court before the court passes sentence?
No, sir.
Mr. Dietrich, on behalf of your client?
Thank you, Your Honor. Judge, Mr. Lucas is, he was on parole this time. He's obviously got a pretty long criminal history, but he is trying to, make his way in the world as best as possible. And I know he struggles with, just the basic necessities of life, housing, employment, maintaining good, friendships that are healthy for him. I think there was a period of time where him and his ex-wife were trying to rekindle, their relationship for the betterment, and there may have been some difficulties, is my understanding, that have arisen. I think that Mr. Lucas probably would benefit greatly from some, counseling services, including rehab services, and he's one of those people. He needs somebody to kind of guide him just for the basic necessities. This is kind of how you do things in life. You get a job, you pay for housing, you get transportation. These are things that I think he didn't have the proper guidance throughout his life. But I think that if he did have the proper guidance, he'd probably be able to avoid the problems that he has continuously had. So I'm hoping that the agreement that was created between the parties will help him have that come to fruition. If I see the probation department's on here as well, and it might be a good idea to just have him. It's almost like I've heard of other states, they have life coaches. And it just seems like Mr. Lucas could benefit from something like that. He's not a bad person. He's not a bad human being. He's not an evil person. He's very soft-spoken. He's very kind in general, and he tries to please people, and that's something I've observed from him over the years. But he just seems to miss the mark at times, and so I asked the court to file the agreement, and giving him the opportunity to attend rehab if he's able to do that. But I also know, or I believe, that he's going to need some type of guidance even after incarceration or even in incarceration, he was trying to get into rehab. I think he's going to need help with that. So I'd ask the court to fashion a sentence that allows those things to happen.
Mr. Webb, on behalf of the people?
Your Honor, our original agreement was a BK to 6 months. Apparently, I missed something given the probation department's recommendation. However, this defendant, as you well know, probably has 9 prior felonies and 17 prior misdemeanors. I was just glancing at his criminal history, and it dates back to 2003. But I'm stuck with my agreement, and I would ask you to follow that.
Oh, excuse me, Your Honor.
Sure.
Oh, I misunderstood, sir. I thought you were asking me if I wanted to say anything about the PSI, but I did want to speak on sentencing.
Go ahead.
Yes, sir. Not to justify any of my actions. I know what I did was wrong, but I just wanted to explain. When I was in the penitentiary, when you sent me there the last time, my whole family passed away pretty much when I was in there. I lost my wife, kids, everything. So I was kind of like struggling in life, where I went to the drug to try to take the pain away, but all honesty, it didn't even take the pain away, it just made it worse. But now I'm clean, you know, doing better. I made a lot of bad choices and a lot of bad mistakes in my life that if I could go back, I'd change every bit of it. You know? When I lost everybody and my kids and wife and stuff, I was just hoping I didn't even wake up the next day. It was just, life was hard, it was rough. I was tired of it, but I'm doing a lot better now. And I'm just asking that you take that in consideration on my sentence, and to still, I know you got to do what your job and for the mistakes I've done, and give me the time for the things I've done. But I'm asking you to take in consideration that I did 9 months in the county jail too. This is all dead time, so I just want to let you know that, sir. And I'm sorry for any bother that I've caused any of you guys.
Since you've been out, have you been in any substance abuse programs? Have you completed any inpatients?
I dropped from my parole officer all the time, and I've been to counseling, and it's a counseling rehab session altogether.
So you're still doing that?
Yes, sir.
Anything further, Mr. Diedrich?
No, Your Honor.
Anything further, Mr. Webb?
No, thank you, Your Honor.
Court has reviewed through the pre-sentence investigation report. Does have sentencing guidelines of 19 to 47 months. In order to punish you for what you have done, to attempts to rehabilitate you, to deter others from committing similar acts of protection of the community, be the sentence of this court, that you be placed on probation for a period of 3 years. Along with the statutory terms of probation, you have the following special conditions. You must not use or possess alcoholic beverages or other intoxicants, or enter any places that serve alcohol. You must comply with the requirements of alcohol testing as directed by your field agent. You must comply with the requirements of drug testing as directed by the field agent. You must not use or possess any controlled substances or drug paraphernalia unless prescribed for you by a licensed physician. You must use prescription drugs only as prescribed for you by your licensed physician. You must attend AA, NA, or CA meetings at the frequency required by the field agent. You must complete an outpatient or residential substance abuse treatment when referred by the field agent. You must complete a substance abuse assessment when referred by the field agent. You must take any medications only as prescribed by your licensed physician. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. You must not have any verbal, written, electronic, or physical contact without permission of the field agent with anyone you know to have a felony record. You must not change your residence unless you first obtain written permission from the field agent. Must not use any object as a weapon. Must contact the supervising field agent no later than the first business day following your placement on probation. You must comply with all written and verbal orders made by the field agent. You must allow the field agent into your residence at any time for probation supervision. You must report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours, weekends, and holidays accepted. You must be in your approved residence between the hours of 10 p.m. and 6 a.m. unless excused by first obtaining written permission from the field agent. You must pay a $68 state cost, a crime victims assessment of $130, court costs of $500, a fine of $500. How much are you charging for attorney fees, Mr. Deaver?
$1,250, Your Honor.
$1,250 in court-appointed attorney fees. The court's going to order you to do 100 hours of community service. If you successfully complete that 100 hours of community service, the court will reduce your fines, costs, and fees by $700. Appears to be no restitution requested by anybody, so there will be no restitution. You are entitled to appellate review of your conviction and sentence. If you're unable to hire your own attorney, the court will appoint an attorney for you and furnish the attorney with the necessary records and transcripts to perfect an appeal. The request for the appointment of appellate attorney must be made in writing within 42 days, sent directly to the court. Please sign the notice of appellate rights. As long as he's on parole, we're not going to charge a supervision fee, but as soon as he's released from parole, then a supervision fee of $30 a month will apply. You must not possess, purchase, or attempt to purchase anything that contains ephedrine or pseudoephedrine without first obtaining permission from your field agent. You must set up an installment payment plan with the clerk's office within 60 days for the payment of those fines and costs. Probation officer of this court or any other supervising agent may, pursuant to MCL 771.4, apprehend, detain, confine a probationer who is in violation of probation condition or who is conducting himself inconsistent with the public good. Court knows it was a BK cap of 6 months, and we know that he's provided, done some dead time in this matter. The court's not going to give him any additional dead time any time at this point. But it's all hanging over your head, Mr. Lucas. Your guidelines aren't good. They're prison guidelines.
Yes, sir, I
So
understand.
you better keep up the good work, stay away from the drugs. Keep your nose to the grindstone, do what you need to do.
Yes, sir.
Good luck to you.
Thank you, sir.
Ms. Medley, any questions for Mr. Lucas?
Just when you do happen to get out of jail, please contact either Agent Ween or another agent. Okay.
Yes, ma'am.
All right. Thank you.
Thank you.
You're all set, Mr. Lucas.
Yeah, thank you.
I do have both Mecosta County and Mr. Federley on. If I can bring Mecosta County in and set him in a breakout room with Todd,
Yes.
then we can go on with Mr. Federley.
Right, I'm sure just bring them both in at the same time and then put Todd and the other one in the breakout room.
Mr. Cool, can you hear me? I need you to unmute your microphone, please. Mr. Cool, I need you to unmute your microphone.
Is that better?
You got, okay, there we go, we can hear you. I'm gonna go ahead and place you into a breakout room with your attorney so that you may speak with him privately. Give me just one moment to do that.
Ma'am.
Okay, Okay, I'm gonna go ahead and do that right now, Todd.
Thank you.
Ms. Tomczyk, can you hear me?
Yes, I can.
Okay, we do have, Mr. Federley on. Mr. Federley, I'm gonna need you to unmute the microphone again.
Mr. Federley, can you hear us?
He's still on mute. I think they control it. He doesn't. control
Can you
it.
hear me, sir?
Yes, now we can hear you.
All right.
On the case of the people versus John Elsa Federley, counsel identified for the record.
Morning, Your Honor. Mark Webb on behalf of the people.
Morning, Your Honor. Karen Tomczyk on behalf of Mr. Federley.
And you are John Elsa Federley, is that correct?
Yes, sir, I am. I'm John Elza Federley.
All right. And this was set for a pretrial. The court has been sent a pretrial summary. Have you received that, Ms. Tomczyk?
I have not, Your Honor. But I know that the court's standard practice would be asking for a jury trial in this and 28 days to file any motions.
All right, okay. And apparently this pretrial just says that there's no reduction. They want them to plead as charged with the sentence recommendation as the guidelines. All right. Do you wish to have a breakout room to talk to Mr. Federley?
Your Honor, I've discussed with Mr. Federley. He has maintained his innocence throughout this process. We've gone over his guidelines, so I think we can just set this matter for a final pretrial, Your Honor, and or a status conference, depending on how the court wants to proceed based on COVID circumstances.
All right. What we'll do is we'll put this on the trial docket with the final pretrial and a trial date being scheduled. Anything further from any party?
Oh, thank you, Your Honor.
No, Your Honor.
All right, you're all set. Mr. Federley, you can sign off.
All right, sir. You have a nice day.
Ms. Tomczyk, have you been in contact with Mr. Federley's grandmother?
I have on prior occasions.
All right, she zoomed in earlier and the clerk mistakenly told us that this was adjourned because we didn't have Zoom communication with Mr. Federley, but then we did get it. So she signed off, so maybe you might want to call her and tell her what's going on.
Okay, I can do that, Your Honor. Thank you.
All right, thank you.
I have a phone number in here. I'm just gonna check and see who this is.
Good morning. Can you please unmute your microphone and identify yourself to the court? Can you
Hello?
please identify yourself? Yeah, what is your name?
Hello, my name is William O'Connor.
All right. Set for 10:20, the Rose case.
Okay, Mr. O'Connor, I'm gonna go ahead and place you back into the waiting room, and as soon as your attorney appears, we can bring you back out for, your case, okay?
All right, thank you.
You're very welcome.
Are you gonna bring up Dallas?
Yeah, that would be great. And then Coakley is right after that, and he's last too.
Yeah, Mr. Cool when the court is ready.
All right.
Okay, let me close that breakout room.
I was gonna say, I thought the discussion was that Mr. Bayless, well, my discussion with probation was that he was no longer lodged.
I show him on the lodge list.
Is that,
Apparently he's large.
okay, well,
Okay.
Okay, we have Mr. Cole back in the courtroom as well.
On the case of the people, this is Lance Leon Cool. Counsel identify for the record, please.
Morning, Your Honor. Mark Webb on behalf of the people.
Morning, Your Honor. Todd Dietrich appearing on behalf of Mr. Cool.
You are Lance Leon Cool.
Yes, Your Honor.
Previously, you appeared in court and pled to the charge of controlled substance possession of methamphetamine, a felony, plus you pled to the habitual criminal third. That made that felony a maximum penalty of 20 years in prison, and minimum discretionary with the court. Pre-sentence investigation report has been prepared. Sentencing guidelines have been determined to be 10 to 34 months. Mr. Dietrich, have you had an opportunity to review that pre-sentence investigation report with your client?
Yes, Your Honor.
Anything of a factual nature that you wish to add to explain or controvert?
Your Honor, Mr. Cool advises that he was actually taken into custody on August 28th in Mecosta County, and that there was a hold on him immediately on that same date from Clare County. And he is requesting additional 33 days of credit.
What we'll do is we'll refer that to the probation department to look into that. They have them listed at 210 days, and they'll check into that. If he was picked up at 28, then and there was a hold on him from Gladwin County, then he's entitled to it. So it depends on Gladwin County put the hold on him.
Judge, I'm sorry. Are you saying Gladwin or Claire? I'm sorry, I can't hear you.
Claire, I said Gladwin, but Claire.
Okay, no problem. So just
Well, let's have him check into it. He's entitled to whatever credit is due. So I don't want to short him up any if he's entitled to it.
Thank you, Your Honor. That's all I had to bring to the court's attention on that PSI report.
If I may, what is the date that you're saying that?
He's claiming arrested on August 28th.
Okay,
in
thank you.
Mecosta County. And then, so it's a question of when the bench warrant was issued for his arrest. I don't know.
Right. So essentially, he's advising me that he was arrested on August 28th in Mecosta County, and that there was a hold on him from Clare County immediately. But the credit given in the report just goes from the arraignment date, which was not until September 29th.
It looks like the warrant was issued on June 12th of 2020, so. All right. Any objection to the scoring of the guidelines?
No, Your Honor.
Dietrich?
No.
Mr. Webb, with the issue of the credit, anything regarding the factual nature of the report or the scoring of the guidelines?
I reviewed the report and I have no additions or corrections to make to it and no issues with the scoring. I believe it's correct.
Mr. Cool, is there anything you wish to say to the court before the court passes sentence?
No, Your Honor.
Mr. Dietrich, on behalf of your client?
Your Honor, Mr. Cool has some other issues going on. Currently, he's incarcerated in Mecosta County. He's appreciative of the prosecutor's office negotiating the settlement with him through this case. I know we've talked in detail about he knows that he has some issues to address, and he's ready to serve his sentence in this case. And he understands that what he did was something he should not have done, and that he's going to be punished for it. And he doesn't make any excuses for himself, to be honest with you. He's a very straightforward person, and he appreciates the opportunity to He knows that the negotiations could have been a lot worse. He wished they had been a little bit better, but he is appreciative. He's expressed his appreciation to the prosecutor's office to me for this negotiated resolution. And he's prepared to go forward to the Department of Corrections to serve out his sentence. And thanks to court for handling this matter.
Mr. Webb, on behalf of the people?
Judge, I'd ask you to follow the plea and sentence agreement and the recommendations.
And Mr. Dietrich, I didn't ask earlier, but Mr. Cool is waiving the right to be sentenced by Zoom, is that correct? Or be sentenced by a president in the courtroom and accepting this Zoom sentencing, is that correct?
It is correct, Your Honor. If I could just inquire of Mr. Cool just to get his voice on the record.
All right.
Yes, Your Honor.
All right. Court has reviewed through the pre-sentence investigation report, does provide for sentencing guidelines of 10 to 34 months, does have a VK agreement of 14-month cap. Court finds that appropriate as it is within the sentencing guidelines. In order to punish you for what you have done, to attempt to rehabilitate you, to deter others from committing similar acts in protection of the community, be sentenced to this court that you be sentenced to the Michigan Department of Corrections for a period of 1 year, 2 months to 20 years. That you be ordered to pay a $68 state cost, pay a crime victims assessment of $130. How much are you charging for attorney fees, Mr. Dietrich?
$1,250, Your Honor.
$1,250 in attorney fees, $300 court costs, and $200 fine. You're entitled to appellate review of your conviction and sentence. If you're unable to hire your own attorney, the court will appoint an attorney for you and furnish the attorney with the necessary records and transcripts to perfect an appeal. The request for the appointment of appellate attorney must be made in writing within 42 days, sent directly to the court. Please sign the notice of appellate rights form when you get it. Bond is canceled. He's remanded to the custody of the Michigan Department of Corrections for carrying out the sentence. Good luck to you, Mr. Cool. When you get out, after you get out on parole, within about 90 days, contact the clerk's office to make arrangements for the payments of the fines, costs, and attorney fees, okay?
Yes, Your Honor.
You're all set.
Thank you.
I think that takes care of all your cases, Mr. Dietrich?
I believe so, Your Honor. Thank you very much.
All right.
We were incorrect about Ballas. We have Michael Ballas incarcerated, not Brandon Ballas.
Okay.
I do not show him on logged on yet.
All right, do we have Ms. Johnson and,
I do not show Ms. Johnson. I show an Angela Altobello, but I don't know.
Janssen's not in our jail?
Cobley is in our jail, I
Okay.
believe. But that's Mr. Rowe. So in terms of Ms. Tomczyk, the two remaining, Johnson and Ballas, I do not show. I have either one in the waiting room.
Ms. Tomczyk, have you had any contact with either Vicki Johnson or Mr. Ballas? Mr. Ballas is not in our jail. A different Ballas is in our jail.
Your Honor, I have not. I contacted the Department of Corrections that gave me an address that I mailed a letter to regarding the court hearing today, but in my discussions with the Department of Corrections, they indicated that although that's the address they have, he is unlikely to be there. I also believe that they have submitted a amended request for bench warrant based on his non-compliance. Ms. Johnson, Your Honor, I'm wondering if that's not a case that I was simply prior on. I don't see that I have an active case with Vicky Johnson. I was her attorney. But that case was closed out in my office in July of last year.
Miss Johnson is actually in Clinton County Jail facing new felony charges.
All right. Did you do an amended or a new motion and bench warrant? I don't see one in the file here.
There isn't a warrant. It's just the show cause.
Show cause, okay. All right, well, it's, I don't even see the show cause in this file, so why don't you do another one? Which means she hasn't been appointed an attorney yet, so why don't we do another show cause for Miss Johnson as long as she's still in another jail.
Okay.
All right. And Mr. Ballas. Is there an amended bench warrant coming for Mr. Ballas?
Yes. Well, I have it on the file. You asked to not put it in until today if he doesn't show.
All right, well, he hasn't shown, so we'll issue the amended bench warrant and we'll up the bond amount. All right.
Okay.
Does the court have a bond amount that it was looking at?
On the old warrant was 2,600, so. And then it was listed at 2,600, but it was reduced.
I believe it was decreased.
It was reduced to 800 cash, so he's posted that. Yes. All right. So, Ms. Medley, if you'll present the court with a new warrant to be signed and put on it also that he's failed to appear here today.
I sure will.
Is the court issuing a bench warrant for his not appearance today or just a new one?
We're issuing a new one, but part of it, because I think he's done something else since that last warrant. And so we're gonna add on his failure to appear here too.
Okay, and the court is issuing that today. I guess my question is if I can try to get a hold of him, are we still looking at the 48-hour grace period, or are we, if we issue a new one, I don't necessarily know that we would have that requirement.
I'll hold off on issuing that till tomorrow. So,
Okay.
All right. I believe that takes care of all your cases, Ms. Tomchek.
Does, Your Honor, thank you.
Cobley is here and they are bringing Austin to the line right now. Mr. Cobley, you can go ahead and unmute that microphone, please.
Calling the cases, the people versus Donald Robert Cobley. Counsel identify for the record, please.
Morning, Your Honor. Mark Webb on behalf of the people.
Your Honor, Austin R. Rowe appearing for Mr. Cobley.
And you are Donald Robert Cobley?
Yes, sir.
All right. We have two cases on the docket today. One is a pretrial for a newer case, pretrial summary has been tendered to the court. Have you received a copy of that pretrial summary, Mr. Rowe?
I have, Your Honor.
Court is signing the pretrial summary. Anything else you wish to do today, Mr. Rowe?
Not concerning that case, Your Honor. Though Mr. Cobley is still open to negotiations, but he does not want to accept anything today.
On either case, is that correct?
Well, I think after my discussion with Mr. Cobley yesterday, Mr. Cobley would like to accept the plea bargain offer in the probation violation case. Is that correct, Mr. Cobley?
Yes, sir.
All right, and what was the offer on that, Mr. Rowe?
Your Honor, that Mr. Cobley would plead guilty to count 1, remaining counts to be dismissed. There's a recommendation of 1 year jail with credit for time served and an unsuccessful discharge from probation, sentence to run concurrent with the Glavin County jail sentence.
Is that correct, Ms. Medley, as far as you know?
Yes, Your Honor.
All right. And you wish to do that today, Mr. Cobley?
Yes, sir.
How old are you?
Excuse me?
How old are you?
39 years old, sir.
Would you raise your right hand and be sworn?
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Mr. Cobley, you're currently on probation for controlled substance possession of methamphetamine. A felony carries a maximum penalty of 10 years in prison, minimum discretionary with the court. Count 1 is violation of Rule 1. There's one of 3 possible pleas you may make to this charge. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stay on mute, in which event the court will enter a plea of not guilty for you. You understand that one of 3 possible pleas you may make?
Yes, sir.
Answering the count 1 violation of Rule 1, how do you plead?
Guilty.
You understand that no one may make any promises for this court as to what your sentence will be?
No, sir.
That means if the court doesn't go along with your plea agreement, the court will allow you to withdraw your plea. You understand that?
Yes, sir.
All right. Court further informs you that if your plea is accepted, you will not have a hearing of any kind and therefore give up the following rights. The right to have a contested revocation hearing, the right to be represented by an attorney, the right to a court-appointed attorney. If you cannot afford to hire your own attorney, the court will appoint one for you. That the maximum possible sentence could be 10 years in prison, the minimum is discretionary with the court. That you give up the right to appear at a hearing, present evidence, cross-examine witnesses. You give up the right to have the prosecution or probation office establish a violation by a preponderance of the evidence. You give up the right to remain silent, not have that silence used against you during the hearing. Then you give up the right to testify at the hearing if you wish to do so and have your testimony considered in the same manner as any other person's testimony. You understand these rights?
Yes, sir.
You understand by pleading guilty, you give up each and every one of those rights?
Yes, sir.
Has anyone promised you anything beyond what was stated in the plea agreement earlier, Mr. Cobley?
No, sir.
Has anybody threatened you or your family in order to induce you to plead guilty?
No, sir.
Has anybody promised you that if you pled guilty, this court be lenient upon you in any way?
No, sir.
Is it your own personal choice to plead guilty?
Yes, sir.
And are you doing so freely and voluntarily?
Yes, sir.
Do you have any questions about what the court has told you?
No, sir.
Have you understood everything that the court has told you?
Yes, sir.
In light of everything that the court has told you, do you still wish to plead guilty?
Yes, sir.
And part of your probation was not to violate any criminal law or of any unit of the government, is that correct?
Yes, sir.
And is it true that on or about August 16th of 2020, you were in the possession of some methamphetamine?
Yes, sir.
And did you have any legal right to have that in your possession?
No, sir.
Court finds a factual basis for the charge. Mr. Rowe, do you agree that there's been a factual basis for the plea?
I agree, Your Honor.
Has the court complied with the court rules, Mr. Rowe?
It has, Your Honor.
Court is satisfied the plea is understandably, voluntarily, and knowingly made. The plea is accepted and ordered in upon the records of this court. I want to see an updated case report, so we'll set sentencing for May 24th at 10:20 a.m. Defendant is referred to the Department of Corrections for preparation of an updated case report. We will also set the other case for a status conference at that time also. Bond is canceled. The case is adjourned to the date time set for sentencing. You're all set, Mr. Cobley.
All right. Thank you, sir.
If I can have a minute just to bring someone in and check if they got it.
Okay, Mr. O'Connor should be still waiting on my phone.
He is. We just have two new people that popped up and I don't know if they're here for a case or for,
okay.
as a.
Yep.
Ma'am, could you please identify yourself? Oh, you need to unmute. You need to unmute your microphone, ma'am. There we go.
I'm Angela Altabello from Craig's Bail Bonds.
Okay, and what case are you here on today?
Justin Schaub.
Okay, that one will be coming up in just a moment. I'm gonna place you back in the waiting room and I'll pull you in when that case comes up, okay?
All right, thank you.
Can you please unmute your microphone and identify yourself for the court? Can you please identify yourself for the court, sir?
Yes, Jamie Sizemore.
Okay, Mr. Sizemore, we have not reached your case yet. I'm gonna go ahead and place you back into the waiting room and we'll bring you back as soon as the judge calls your case, okay?
Yes, ma'am.
Thank you. Okay, and then Mr. O'Connor, right?
Calling the case of the People versus William Marion O'Connor. Counsel identify for the record, please.
Morning, Your Honor, Mark Webb on behalf of the people.
Your Honor, Austin R. Rowe, appearing on behalf of Mr. O'Connor.
Your Honor, William.
Go ahead.
Your Honor, William Marion O'Connor.
All right. And this was set as an arraignment. How do you wish to proceed today, Mr. Rowe?
Your Honor, Mr. O'Connor waives the reading and he pleads not guilty.
All right. Not guilty pleas will be entered on behalf of Mr. O'Connor. This will be set on the trial docket with a pretrial being scheduled next. You're all set, Mr. Connor. You can sign off.
All right, thank you.
I don't see Mr. Schaub on it, which might be why he's here. Just a moment.
Find the case of the people versus Justin Allen Schwab. There's the file. Counsel identify for the record, please.
Your Honor, Austin R. Rowe, appearing on behalf of Mr. Shaw.
Mr. Webb, you gonna put in an appearance or?
No, it looks like it's a,
It's just a bond,
Sure.
revocation and forfeiture, yes.
against the surety. Yep.
Appearing on behalf of the bond company,
Angela Altabello.
well, Mr. Schwab failed to appear at his last court date. His bond was canceled and forfeited. A new bench warrant at $50,000 cash was set. Anybody hear from Mr. Schwab?
I have not, Your Honor.
Anything on behalf of the bond company?
Our recovery team is working very hard to bring Mr. Schaub in. They've been a couple steps behind him, but they're confident in bringing him in if they were to get some more time for this, Your Honor.
Yeah. Well, under the law, they have about a year to bring them in and to keep their money, so that's plenty of time. All right. Anything further?
No, Your Honor.
All right, we're all set for today. Thanks for calling in.
Your Honor, I believe that concludes my cases before the court today.
I believe it does.
Have a good day, Your Honor.
You too. We're in recess. Do we have Mr. White on or?
We do, Jerry just hopped on, but we have Tara Hovey and James Otto on as well, and they are a little bit later of a case, but they've been on for a few minutes.
All right, so we can take that.
Let me bring them into the courtroom.
I don't actually see a bench warrant from Mr. Schwab in this file, so we need to check on that, make sure one was issued.
Okay.
And that it's been in the system. Find the case of the People versus James Junior Auto. Counsel identify for the record, please.
Morning, Your Honor. Mark Webb on behalf of the people.
Good morning, Your Honor. Tara Hovey appearing on behalf of James Otto.
You are James Junior Auto?
Doesn't appear as though he has any audio connected.
All right. You need to unmute your phone or device.
It doesn't even show that he has audio connected, which means when he logged in, he dismissed the audio on it. I don't know if Tara has a way to contact him.
What do you need me to do, Judge?
He apparently needs to sign back off and log in with audio, because apparently when he signed on, he signed on without audio, and I don't know if it'll let him unmute or not.
I don't know what's going on with him at this moment, so.
It looks like it's trying to connect to audio now, so he might have.
Okay, he's trying now apparently.
There we go.
I see the microphone sign.
There we go. Mr. Otto, can you unmute your microphone, please?
James, it's gonna be the red microphone looking thing on the phone. You gotta tap that to unmute. There you go.
Okay.
You are James Junior Auto?
Yes, sir.
Today's scheduled as a pretrial summary has been prepared. Have you received a copy of that summary, Ms. Hovey?
Yes,
Yeah.
John.
And at this point, my client does wish to accept the offer from the prosecutor.
All right. How old are you, Mr. Otto?
51.
Would you raise your right hand and be sworn?
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
And Ms. Hovey, is he waiving reading of the information?
That is correct, Your Honor, and specifically waives the preliminary examination as well.
All right. Mr. Otto, you have seen the information and gone over that with your attorney, is that correct?
Yes.
You're being charged with weapons carrying concealed. That's a felony that carries a maximum penalty of 5 years in prison and/or a $2,500 fine, and includes mandatory forfeiture of the weapon or device. The minimum is discretionary with the court. You understand that?
Yes, I do.
There's one of three possible pleas you may make to this charge. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stand mute, in which event the court will enter a plea of not guilty for you. You understand the one of three possible pleas you may make?
Yes.
Answering to the charge, weapons carrying concealed, how do you plead?
Guilty.
You understand that no one may make any promises for this court as to what your sentence will be?
Yes.
Court further informs you that if your plea is accepted, you will not have a trial of any kind and therefore give up the following rights: the right to have a trial by jury, the right to have a trial in front of this court sitting without a jury, the right to be presumed innocent until proven guilty, the right to be proven guilty beyond a reasonable doubt, the right to question all witnesses against you, the right to have this court order witnesses on your behalf into court to testify at trial, the right to remain silent and not have that silence used against you during trial, and the right to testify at trial if you wish to do so, and have your testimony considered in the same manner as any other person's testimony. Do you understand these rights?
Yes, I do.
You understand by pleading guilty, you give up each and every one of those rights?
Yes, I do.
Mr. Webb, what is the plea agreement?
Your Honor, it's my understanding that in exchange for the defendant's guilty plea to carrying concealed weapon, we will recommend a Briggs Killebrew sentence of a 1-year delay. If he successfully completes that 1-year delay, then the charge would be dismissed.
Ms. Huffey, is that your full and complete understanding of the plea agreement?
It is, Your Honor.
Mr. Otto, did you hear what was put on the record as the plea agreement?
Yes, I did.
Did you understand it?
Yes, I do.
And are you in agreement with it?
Yes, I am.
Has anybody promised you anything beyond what was stated in the plea agreement to induce you to plead guilty?
No.
Has anybody threatened you or your family in order to induce you to plead guilty?
No, Your Honor.
Has anybody promised you that if you pled guilty, this court would be lenient upon you in any way?
No, Your Honor.
Is it your own personal choice to plead guilty?
What was that?
Is it your own personal choice to plead guilty?
Yes.
Doing so freely and voluntarily?
Voluntarily.
Do you have any questions about what the court has told you?
No, Your Honor, I don't.
Have you understood everything that the court has told you?
Yes, I have.
In light of everything that the court has told you, do you still wish to plead guilty?
Yes.
Drawing your attention to on or about March 11th of 2021, were you in the city of Clare, Clare County, Michigan?
Yes.
And did you have in your possession a pistol?
Yes.
And was it concealed or otherwise in a vehicle operated or occupied by you?
Yes, it was.
Mr. Webb, any questions or are you satisfied with the factual basis?
If I may, Your Honor.
You may.
Mr. Otto, where vehicle?
What was that?
Where was this pistol in your vehicle?
It was in the council.
And you don't have a CPL or a license, right?
No, I don't. I can explain what happened. It
Oh,
was
that's-
very,
That's okay. I have no more questions, Your Honor. Thank you.
okay.
Satisfied with the factual basis, Ms. Hovey?
Yes, Your Honor.
Has court complied with the court rules, Mr. Webb?
You have, Your Honor.
Has court complied with the court rules, Ms. Hovey?
You have, Your Honor.
Court has not agreed upon the possible plea or the possible sentence of either the prosecutor or defendant or anyone acting in the interest of either. Court is convinced the plea is accurate and has been freely, voluntarily, understandingly, and knowingly made. Plea is accepted and ordered entered upon the records of this court. Sentencing will be set for June 14th at 10:40 a.m. Defendant is referred to the Department of Corrections for the preparation of a pre-sentence investigation report. Bond is continued. Case adjourned to the date time set for sentencing. Ms. Medley, any questions or information for Mr. Otto?
Yes,
No, sir.
Mr. Otto, what is your phone number?
989-621-3210.
And are you still living on Blanchard Road?
Yes.
Okay. Our office will mail you some packets
Okay.
with an agent to contact. Fill out those packets and then call that agent as soon as possible.
I will do that.
All right, thank you.
Okay, thank you.
You're all set, Mr. Otto.
Thank you, sir.
We have Jerry on now. We do not have Corey Woodbury available, but I
Let's
can
bring in
bring
Mr. Sizemore then.
Mr. Sizemore and or Mr. Pritchard. I do have Mr. Pritchard.
Okay, either one.
So, your first one will be, heavy, but, yeah.
Calling the case of the people versus Trevor Michael Pritchard. Counsel identify for the record, please.
Morning, Your Honor. Mark Webb on behalf of the people.
On Your Honor, Gerald White, representing Mr. Pritchard.
You are Trevor Michael Pritchard? You need to unmute.
That's exactly what, I don't even need the laundry so much, but.
You are Trevor Michael Pritchard?
Yes, Your Honor.
This was said as a pretrial. Has there been a pretrial summary done in this matter?
There has been, Your Honor, and I am in possession of it.
All right. And do you wish to proceed with that or continue on the trial docket?
No, we wish to proceed with that, to enter a plea in this matter pursuant to the pretrial statement.
All right. And what is the offer? I don't have a pretrial summary in front of me.
Oh, I'm sorry. Defendant would plead guilty to the possession, count one, of a narcotic psilocybin, I believe it's the way to pronounce it. And and upon the acceptance of that plea, there would be a dismissal of count two at sentencing time. The sentence recommendation is a 1-year delayed sentence that will be reduced to a use charge upon successful completion of the delayed. And I believe that substantially puts the offer that I'm aware of.
Mr. Pritchard, how old are you?
I'm 23, Your Honor.
Would you raise your right hand and be sworn?
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Thank you very much.
So help me God.
And Mr. White, is he waiving reading of the information?
Yes, Your Honor. Thank you.
And waiving preliminary examination, is that correct?
Also correct, Your Honor.
And Mr. Pritchard, you've gone over the information with your attorney, is that correct?
Yes, Your Honor.
You're being charged with count one, controlled substance, possession of a narcotic less than 25 grams. That's a felony. It carries a maximum penalty of 4 years in prison and or a $25,000 fine. And it may or may not include license sanctions. Otherwise, the minimum is discretionary with the court. Do you understand the charge and the possible penalties?
Yes, Your Honor.
There's one of three possible pleas you may make to this charge. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stay on mute, in which event the court will honor a plea of not guilty for you. Do you understand the one of three possible pleas you may make?
Yes, Your Honor.
Answering to count one, controlled substance, possession of a narcotic less than 25 grams. How do you plead?
Guilty.
You understand that no one may make any promises for this court as to what your sentence will be.
Yes, Your Honor.
Court further informs you that if your plea is accepted, you will not have a trial of any kind and therefore give up the following rights. The right to have a trial by jury, the right to have a trial in front of this court sitting without a jury, the right to be presumed innocent until proven guilty, the right to be proven guilty beyond a reasonable doubt, the right to question all witnesses against you, the right to have this court order witnesses on your behalf into court to testify at trial, the right to remain silent and not have that silence used against you during trial, and the right to testify at trial if you wish to do so and have your testimony considered in the same manner as any other person's testimony. Do you understand these rights?
Yes, Your Honor.
You understand by pleading guilty, you give up each and every one of those rights.
I understand.
Mr. Webb, is there anything different than what, to that plea agreement than what Mr. White said earlier?
There is not, Your Honor.
All right. And Mr. White, that was your full and complete understanding of the plea agreement?
It is, Your Honor, yes.
Mr. Pritchard, did you hear it was put on the record as a plea agreement?
Yes, Your Honor, I heard.
Did you understand it?
Yes, sir, I did.
And are you in agreement with it?
Yes, I'm in agreement with it.
Has anybody promised you anything beyond what was stated in the plea agreement to induce you to plead guilty?
No, Your Honor.
Has anybody threatened you or your family in order to induce you to plead guilty?
No, Honor.
Has anybody promised you that if you pled guilty, the court would be lenient upon you in any way?
No, they have not, sir.
Is it your own personal choice to plead guilty?
Yes, Your Honor.
And are you doing so freely and voluntarily?
Yes, sir.
Do you have any questions about what the court has told you?
No, Your Honor.
Have you understood everything that the court has told you?
Yes, sir.
In light of everything that the court has told you, do you still wish to plead guilty?
Yes, Your Honor.
Drawing your attention to on or about October 21st of 2020, were you in the village of Farwell, Clare County, Michigan?
Yes, Your Honor.
And did you have a controlled substance psilocybin in your possession?
Yes, sir, I did.
And was it less than 25 grams?
Yes, sir, it was like 2 grams.
And did you have any license or prescription to have that in your possession?
No, Your Honor.
Satisfied with the factual basis, Mr. Webb?
Yes, Your Honor.
Satisfied with the factual basis, Mr. White?
Satisfied, Your Honor, yes.
Has the court complied with the court rules, Mr. Webb?
Yeah, Your Honor.
Has the court complied with the court rules, Mr. White?
Yes, Your Honor.
Court has not agreed upon any possible plea or possible sentence with either the prosecutor or the defendant or anyone acting in the interest of either. Court has convinced the plea is accurate, has been freely, voluntarily, understandably, and knowingly made. plea is accepted and ordered entered upon the records of this court. Sentencing will be set for June 14th at 9:20 a.m. Defendant is referred to the Department of Corrections for the preparation of a pre-sentence investigation report. Bond is continued. Case is adjourned to the date time set for sentencing. Ms. Medley, any questions for Mr. Pritchard or any information for him?
Yes, Mr. Pritchard, what is your phone number?
989-487-9271.
And are you still living at 5172 West Ludington Drive?
Yes, ma'am.
Okay. Our office will be mailing you packets for you to fill out. On the bottom of the one packet, it'll have the name of an agent and a telephone number for you to contact that agent as soon as you're done with the packets. Okay?
Okay.
All right, thank you.
You're all set, Mr. Pritchard. You can sign off. Calling the cases of the people versus Jamie Lorenzo Sizemore Jr. Counsel identify for the record, please.
Morning, Your Honor. Mark Webb on behalf of the people.
Good morning, Your Honor. Gerald White representing Mr. Sizemore in the 3 matters that are pending before the court.
And you are Jamie Lorenzo Sizemore Jr.?
Yes, sir.
All right, and some pretrial summaries have been submitted to the court. Have you received those, Mr. White?
I have, Your Honor.
And does your client wish to take advantage of them today or have this case continued on the trial docket?
Continuing on the trial docket, if you will, Your Honor.
All right. Court is signing the pretrial summaries. This will continue on the trial docket with a final pretrial and a trial date being scheduled next. We'll send those out to you, Mr. White.
Thank you very much, Your Honor, for your help.
You're all set, Mr. Sizemore. Keep in contact with your attorney about those next court dates.
Thank you, sir.
Mr. White, have you had any contact with Mr. Williams? Is he still in the Roscommon County Jail or?
I do know that he's not in the Clare County Jail, Your Honor, so my presumption is that he's in the Roscommon County Jail.
Okay. Of course, he could be in another county too, because I think he had cases in 2 other counties, so.
That's true, but the last I knew, he was in Roscommon, Your Honor.
All right, well, they have not called in today, so.
Do you want me to have our office work on getting in contact with Roscommon County right now? Or,
We could, I don't know.
and I don't show Mr. Woodbury either.
Okay. Have you had any contact with Mr. Woodbury?
Not at all, Your Honor. He's still at large, from what I understand. I called the jail today. He's not a resident of our facility.
All right. Can I see the file, Mr. Woodbury?
Did the court receive the waiver of arraignment on Mr. Mike Schmier, Your Honor?
Yes, we did.
Okay, fine. Thank you.
All right. Calling the cases of the people versus Corey Michael Woodbury. Counsel identify for the record, please.
Morning, Your Honor. Mark Webb on behalf of the people.
Morning, Your Honor. Gerald White representing Mr. Woodbury on 2 files.
All right. And on file number 20-6452-FH, set for show cause why judgment should not be entered against the surety for failure to appear. Bench warrant was issued against Mr. Woodbury. He's failed to appear here again today. And we've had nobody sign in from the surety company. So forfeiture will go through, although they have about a year to pick up the defendant and return them. So we won't schedule any more court dates until Mr. Woodbury is apprehended.
Very well, Your Honor.
All right. So the court staff is going to contact Roscom and see if we can get Mr. Williams online. Do we have Mr. Hovey appearing?
I do not show Mr. Hovey either.
Calling the case of the people versus Stephen William Hovey. This is a show cause for a probation violation. He's failed to appear. Summons was sent with a 3-count violation. So we're going to go ahead and issue a bench warrant for Mr. Hovey's arrest. Bond in the amount of $5,000 cash. Court is in recess.
All right.
You're all set, and as soon as you file this in our office, we'll mail you each out a true copy of your judgment, okay?
Okay, do I just pick that up at the circuit court office, clerk's office?
If you'd like to pick it up immediately, you can do so. Just give our office a call and let them know that you'll be picking it up. If we don't hear from anybody today, we'll send it in the mail this afternoon.
Okay.
Okay, it would be tomorrow. Yep, all right, thank you.
No problem.
Bye-bye.
All right. 55th Circuit Court is now in session. The Honorable Roy G. Meek presiding.
You may be seated. Behind the case of Catherine Misko versus Dana Hayward, counsel identify for the record, please.
Yes, Greg Jane on behalf of the plaintiff.
Good afternoon, Your Honor. Caitlin Dodge on behalf of Defendant Hayward.
The pretrial, are the pleadings sufficient, Mr. Dan?
Yes.
You agree? Caitlin?
Yes, I agree.
All right. Exchange names and addresses of known non-expert witnesses within 28 days, later discovered as they are discovered, but no later than 14 days before trial. Same thing with exhibits. Plaintiff has 60 days to name their experts. Defendant has 90 days. Court likes to have jury instructions and verdict forms at least 7 days before trial. defendant reserving the right to have independent medical reports. Did you hear the court? Or defendant, are you reserving the right to have independent medical reports?
Your Honor,
Discovery will be left open so long as it doesn't interfere with trial. The earliest time you'll be available for case evaluation?
Oh, when are you doing them in the fall?
Every odd month. So
Every odd-
September, October.
We should be ready by, October.
yeah, October sounds fine.
Okay. If it goes to trial, about how many days are we looking at?
2 to 3.
You agree?
I agree.
You want to set trial for December or January?
Doesn't really matter.
Yeah, we can do January.
All right. All claims been joined?
Yes.
Does anybody want anything else put in this pretrial summary?
Nothing else for plaintiff.
Nothing else from defense.
All right. Anything else you want to discuss at this time?
No, nothing else.
Nope, that's all for me too.
All right, thanks for calling in.
All right,
Thank you, Your Honor.
Our hubby is on, but we do not have the defendant.
We're not going to either, but
Oh, we won't have the defendant on?
they've been defaulted.
Oh.
Well, they haven't been, the default hasn't officially gone through, but they ended up doing a notice of publication.
Is that pre-trial?
Yeah, I want to wait something out. Yeah, some wait out.
So do we just want to bring Tara in and go on, or are we gonna wait until?
No, you can bring her in. I don't think there's anybody else going to be coming in.
Thank you.
Calling the case of Sean Berger versus Barbara Calcaterra.
Good afternoon, Your Honor. Tara Hovey appearing on behalf of Mr. Berger in this matter.
And sure you don't expect any defendants to show up, is that correct?
Your Honor, in this matter, this is a quiet title action. Through the course of our attempting to serve Ms. Calcaterra, we determined that she was ill. We did post or publish, and no one has stepped forward, Judge.
All right. You may proceed.
Thank you, Your Honor. Your Honor, we are requesting the court enter an order to quiet title. In this matter, Mr. Berger did purchase the real property from the Clare County Treasurer. Due to the non-payment of the real taxes pursuant to statute, he is entitled to clear title, and therefore we're requesting the court to enter an order to quiet title in this matter.
From the file, there's proof of service by publication, and the default's been entered. Court will grant the order.
Thank you, Judge.
We're in recess.
Thank you, Judge. Have a good afternoon.